Good afternoon. Welcome to the Appellate Division, First Department. We have over 6 hours of argument time requested, so only ask for the time that you need, not the time you wish. We are familiar with all the briefs and the records, and if we have further questions, we will definitely keep asking them. People versus Mobley. Appellant? Respondent? 4, 2, and 3. Hefty versus New York State Division of Housing. Appellant? Respondent? How many are you asking? Well, I'll give you each separate time. Okay, and is the landlord here? It doesn't appear actually that the landlord is here. Okay, so I'm going to give the move-in 4 and 2, and you'll get 5. Sheila versus Stormello is submitted. Kozak versus Kushner Village. Appellant? Respondent? 5, 2, and 5. People versus Higgs. Appellant? Respondent? 4, 1, and 4. People versus Checo. Submitted. Mercer Square versus Namdor. Appellant? Respondent? Do you want any rebuttal time since you're... Okay, 5 and 2 and 3 and 1. DeMar Plumbing versus City of New York. Appellant? Respondent? 4, 1, and 5. LW Holco versus Pools. Appellant?
I don't see the appellant, Your Honor.
Do you want to submit then?
If I may just have 2 minutes to make one point and answer the questions.
Sure, 2 minutes. Carl versus Julian. Appellant?
5 and 3, please.
I'm sorry, what? You are for the... Okay, 6 and 1, 5 and 3. People versus Rios is submitted. Board of Managers versus JMA Consultants. Appellant? Respondent? 6, 1, and 6. People versus Clyde Blanding. Appellant?
Good afternoon. Upon request 4 and 1, please.
4, 1, and 4. Mashia versus Pinar. Appellant?
Good afternoon. 6 and 3, please. 6 and 3?
Respondent? I'm sorry?
3 and 2.
Well, you don't have a cross appeal, so you just get 6 and 1 and 3. People versus Santiago.
Request 4 and 1.
Respondent? 4, 1, and 4. Joseph versus Morsal. Do you wish to submit, since there's no one arguing on the other side? Okay, I'll give you 3 minutes. People versus Thomas. Appellant? Respondent? 5, 1, and 4. Mingo versus Rec Access is submitted. Transit versus Mott Haven is submitted. And Leffler versus Kotick is submitted. And the first case is People versus Mobley. Go ahead.
Good afternoon, and may it please the court. Jane Merrill for Appellant Corey Mobley. As the prosecution below conceded, Mr. Mobley discarded the gun in this case as a direct result of the police officer's actions. The question for this court is whether those officers' actions constituted permissible observation or impermissible pursuit. This court enunciated the standard for pursuit in People v. Collins, holding that where the objective impact of police activity is intimidating and communicates an attempt to capture or intrude upon an individual's freedom of movement, the officer's actions constitute pursuit. And that is exactly what we have here. Mr. Mobley was walking alone down the street at about 4:30 in the morning when all of a sudden and out of nowhere, a car sped at him, making a U-turn across traffic to drive the wrong way down a one-way street. One officer jumped out of the car and followed at a very close distance behind him, while the other officer pulled up ahead of Mr. Mobley.
Did the officer approach him in any way, though, or speak to him any way before the officer allegedly saw the gun being thrown?
No, he did not, but that's not...
So you're saying just the fact that he was following him closely and the actions of the other vehicle were enough to have a higher level of scrutiny required?
It was. It's because it's not mere following here, because it wasn't just that one officer. I do think it's possible if it had just been that one officer that wouldn't be intimidating and communicate the same attempt to capture that it did.
Counsel, how do you distinguish this case from People v. Quinton, where this court found that it was permissible for an officer to make a U-turn and follow someone?
I'm sorry, I didn't hear the name of the case, Your
People
Honor.
versus Quinton?
In that case, Your Honor, I'm sorry, I just want to consult my notes.
The facts were similar, where there was a U-turn and someone going down the wrong way.
The facts were similar, but in that case, the police car did not block the defendant's course, and that was, I believe, just the one police car.
Here, the blocking of the defendant's course happened allegedly after the firearm was discarded, right?
The record is somewhat unclear at that point. I don't think that's dispositive because there was both of these two officers moving simultaneously, Your Honor. There was the one behind him and the one in front of him, which does make it different from Quentin.
What did the officer say to him, the one that was following him?
The officers did not say anything until Mr. Mobley had already discarded the gun, which
Correct.
I do think undercuts the notion that this was an approach to request more information to clarify a confusing or unclear
Well, things are happening rather quickly, right? I mean, the officer exits the vehicle, based on the testimony I see here, exits the vehicle, takes a few steps, and then sees the defendant, according to his testimony, toss something to the left, to his left under the trailer. And at that point, that's when the officer says, you know, please, you know, I want to talk to you.
Things absolutely happened quickly, Your Honor, but not so quickly that the officer could not have, when he stepped out of his car, asked for the information that he wished to clarify. And I do think that's what makes clear that this was pursuit, that there was no request for information. There was just these two officers pretty quickly closing in.
Well, they also, as they were in the car, the testimony was that the officer who exited the car was noticing that he was fidgeting with his fanny pack, that he was doing other movements that gave rise to something, a cause for concern for the officer after hearing about, you know, the shots being fired alert.
Absolutely, Your Honor. I think all of that does indicate that there was an objective, credible reason to approach. It falls short, certainly, of probable cause. The shot spotter, and I'll address this on rebuttal, did not generate reasonable suspicion here.
Thank you.
Thank you.
May it please the court, Larry Glasser for the respondent. In this case, as counsel just conceded, when the police officers got out of the car, they had at least a DeBoer level 2 objectively credible reason to approach the defendant. And I find it quite curious
Based
that—
on his observations of what he was seeing the defendant do as he was walking, right, fidgeting, moving his fanny.
Well, in addition to the hearing a gunshot, getting confirmation of the gunshot from ShotSpotter, which I'm not arguing that the ShotSpotter alert by itself provided level 1 or level 2, but it was confirmation of the officer's own hearing a shot, then his observations of the defendant not only leaving the group, but a marked police car drove down the block, shined its spotlight on the group. The defendant bladed his body in a way that put his body between that police car and the fanny pack he was carrying. He then started fidgeting with the fanny pack. One of the officers testified at the hearing that he was a very experienced sergeant. He had cases before, and he had known of suspects who carried guns in fanny packs. This at least provided an objectively credible reason to...
But there was no testimony that the officers had any objective basis to believe that the defendant had a firearm at that moment, right?
Right, and that's correct. And that's why I find it curious that counsel said they should have gotten out of the car and they could have questioned him right away. They did not stop him. They did not impede his freedom of movement. They did not interact with him in any way. And what counsel does, respectfully, is contradicted by the very clear record of the hearing, which lays out the undisputed sequence of events. One officer got out of the car, followed behind the defendant. As Your Honor had said, he did not say anything.
Right.
He was close behind him, but as this court said in Hill, this doesn't even rise to a DeBoer stop because the officer was walking in a place he was allowed to walk. He didn't say
Counsel,
anything.
if I may, I'd like to address the written waiver of appeal that the defendant signed.
Yes, Your Honor. Well, the written waiver explicitly said, and I will quote from it, that the defendant was waiving, I want to make sure I get the language correctly, the resolution of any suppression motion that I may have made. And the defendant stated he consulted with his attorney, he discussed it with his attorney, he understood everything in the waiver. The waiver itself says, has him acknowledge that he doesn't have to sign it if he has any questions, and he's allowed to ask the court or his counsel if he has any questions about it. He was properly allocated by the court as to the waiver. Counsel argues that the oral colloquy was somehow defective, but it wasn't, Your Honor. What the court did in its oral colloquy is it provided one example to the defendant of the things being waived, and it said something like the legality of the evidence. It didn't say that was the only thing being waived. It didn't say that related to the suppression. It was an example of just one thing. And as I said in my brief, and as the Court of Appeals has stated, while a defendant has to be informed of the issues that survive a waiver, they don't need to be told of all of the claims that they are particularly waiving.
Thank you.
Thank you very much.
Briefly, just as to the substance here, respondent focuses entirely on the actions of...
Why don't you actually talk about the waiver of appeal? Because if there's valid waiver of appeal, we don't even get to the merits.
Yes, Your Honor, the appeal waiver here was not valid.
What about the fact that the written waiver specifically specified that they waived anything in connection with the suppression?
The written waiver absolutely does. However,
Why is
Your
that
Honor,
not coupled with the oral waiver that occurred? Why isn't that sufficient?
this court has repeatedly held that a written waiver cannot cure the deficiencies in an oral colloquy when the oral colloquy conflicts with the written waiver. And that's particularly important here because the court did not discuss the written waiver with Mr. Mobley at all. He made
Is the court required to discuss the specifics of the written waiver with the defendant?
not required to discuss the specifics, but is required to ensure that the defendant has read the waiver, has understood the waiver, has discussed it, and that the defendant signs it in open court. That is wholly absent from the record in front of Your Honors. So because that written waiver was not discussed with Mr. Mobley at all, it cannot cure the issue here. And the issue, while admittedly is maybe not blatant to all of us in this room, lawyers who can understand that a judge, when he says the legality of the evidence, that is entirely unclear to someone who is a layperson. The plea hearing here took place
Counsel, if I may, I was under the impression that the defendant did respond to the court, that he reviewed the written waiver, he discussed it with counsel, and he had no questions about it.
The record here is much less fulsome than it is in a typical colloquy about a written waiver. So I can go back to the record, but I don't believe
Okay, let me ask you another question, because this is certainly not the first time that defendant appeared in court. I think there were at least, 8 convictions, and all of them were from a guilty plea, no?
Respondent did point that out, and that's accurate. However, there's no evidence in the record or elsewhere, as far as I know, that Mr. Mobley waived his right to appeal in any of those, which I do think means that this court cannot assume that he had knowledge of what a waiver of appeal would do. So absent that, thank you, Your Honors.
Hefty versus GHCR.
Good afternoon, Your Honor. As the court knows, all of this began with Cindy Lauper, more specifically with her husband, David Thornton, an actor who challenged the four-year look-back rule, and we have them to thank for the fact that we've evolved from there. I'm just trying to set the groundwork for where we are in terms of the standard that DHR was supposed to have applied, but because they did not apply, their order was in fact arbitrary, capricious, an abuse of discretion, contrary to law, and not based on the record. And therefore, Judge Headley should have granted my Article 78, and I pray that this court will reverse that. In any event, as this court knows, we moved from the standard in Thornton, which involved an illusory tenancy, as this court knows, and then was reviewed again in matter of Grimm, all the way up to Regina, the matter of Regina. And the dissent in Regina, written by the current Chief Justice, Rowan Wilson, makes clear the fact that I'm hoping to God that this case doesn't have to go to the Court of Appeals, but I'm just saying, if it were to, I believe that the new Chief Justice, relatively new Chief Justice, would take the opportunity to correct what the previous court got wrong about Regina. But all of that is, in some regard, beside the point, because obviously what I'm discussing is a fraudulent scheme, and the DHR was supposed to look back beyond the four-year look-back rule. But that's the reason I say it's in some regards beside the point is because from the beginning of this case, I did allege a colorable claim of fraud. So regardless of Regina and all of the rest of the cases that evolve forward from David Thornton bringing his now famous case, Thornton v. Barron, all the way up to the present time, I alleged a colorable claim of fraud all along, which should have triggered the DHR to look back at the gross rent overcharge that went from the time that Margaret Smoke, the long-term tenant, vacated the apartment in 2001. The landlord failed to register the apartment, unlawfully failed to register the apartment in 2002. And then when he put the apartment back on the registry in 2003, somehow the rent went from $42.67 to $1145.93. There is no explanation for that jump. The DHR has never tried to explain it. The landlord has never tried to explain it because it's inexplicable. It was nothing but a fraudulent rent registration, specifically the kind of registration that both the courts and the legislature have tried to address, whereby New York State has lost tens of thousands of rent-stabilized apartments in the exact same kind of scheme where a landlord raises the rent, hopes the 4 years go by, and then it becomes the de facto rent. The DHR may resent the idea that anybody should have a much more reasonable rent, but that's also beside the point. It's the law. They've never looked at it, and the Callahan order, which they continue to raise as though it's like an invisibility shield, which it is not, makes clear and evidences the fact that they never looked back before June 29, 2001 at the rent history, which clearly shows the overcharge. And the reason that they never did is because at that time, the law was 4 years.
You'll have more time on rebuttal.
Say what?
You'll have more time on rebuttal. But
Thank you.
Your time
Sorry,
is up.
I'm sorry, I'm very
No,
nervous.
don't be
I'm
sorry.
pro se.
No, it's okay. You'll have more time to speak on the rebuttal time. No need to apologize.
Good afternoon, Your Honors. May it please the court. My name is Dawn Ivy Schindelman, and I represent the respondent, New York State DHCR, in this proceeding. The issues in this appeal are very clear and limited. It's whether the lower court properly affirmed DHCR's final administrative determination upon remand, and whether the lower court properly denied the tenant's subsequent motion to re-argue and renew the same. It's DHCR's position that the lower court properly upheld DHCR's remand par order, finding it was neither arbitrary nor capricious and in full accord with applicable law and rationally based on the administrative record, and also that the lower court found that the tenant was not entitled to renew and re-argue the initial, excuse me, the initial determination. And if you have any questions, I can.
Any questions? No? Thank you.
You will.
Do I still get my rebuttal?
You have 2 minutes for rebuttal, yes.
I'm so sorry.
No need to be
I just realized
sorry.
I didn't even introduce myself. I really apologize. I'm a nervous wreck. I know I don't always look it, but I'm panicked, so I apologize. I'm Susan Catherine Hefty, and I am the tenant of almost 19 years of my tiny little studio apartment at 179 East 93rd Street. I apologize. In any event, I guess since there weren't any other issues really raised there, I'll just pick up where I left off, if I may, unless you have questions right off the top, or may I just finish that point I was trying to make? Thank you. So, okay. So, as this court also knows, in addition to the little history lesson that you didn't need, and I jumped through quickly, March 1, 2024, the legislature took it upon itself to try to correct what it felt the courts, lawyers, everybody was they thought, getting wrong about how do we determine a fraudulent scheme. So, as you all know, the legislature defined fraud. I actually went online and read a whole bunch of articles written by landlord lawyers, and they're busy trying to make it sound confusing. I think it's not confusing at all. I think it's very plain. What the legislature said was that the DHCR and the courts were to consider the totality of the circumstances. In this case, the totality of the circumstances make it absolutely irrefutable that this is and was, in fact, it's an ongoing fraudulent scheme. Landlord Goffman didn't only unlawfully deregulate my apartment for more than a decade until I got it re-registered through my original case that was filed in 2017. He's also unlawfully deregulated 6 other apartments in the same building. Other tenants filed to intervene, as you know from the record, and Judge Headley said, no, you can't intervene because Judge Getz already said you can't intervene in that case, which had nothing to do with this case. In any event, okay, totality, okay.
Your time's up, but we will read all the briefs and look at everything before we make any decision. Thank you so much.
I'm sorry.
No need to be sorry whatsoever. Kozak versus Kushner?
Good afternoon. Robert Grimble and the Judas for the appellant. Your Honor, this is an action that was commenced as a putative class action on the motion for certification. It was a cross motion, rather specifically under CPLR Rule 3212, not under CPLR Rule 3211, seeking to dismiss the case.
Let me ask you a specific question. Why are you not required to exhaust your administrative remedies as a trial court found, since you're challenging the decision of the Department of Buildings to extend the temporary certificate of occupancy beyond the 2 years? Why isn't this an exhaustion question? Why shouldn't the DHCR, I'm sorry, not the DHCR, easy to confuse, the building department be present to have a voice in whether the actions they have done in extending the temporary certificate of occupancy beyond 2 years is illegal?
Well, That's actually two questions. The first is, why do you not exhaust your administrative remedies? And the answer is, there is no administrative remedy. If the DOB...
Well, why couldn't you go to commence an Article 78 proceeding against the Department of Buildings and say, hey, you exceeded your statutory authority and your actions in extending that were invalid, and therefore you should revoke that temporary certificate of occupancy?
Well, again, if you brought an Article 78 proceeding, it would have to be in the nature of mandamus, and it's in the nature of mandamus against a non-ministerial task. So you're sort of procedurally doomed from the
Why
start.
does it have to be a writ of mandamus? Why can't it just be an action saying that they didn't have the authority to extend the temporary certificate of occupancy?
You're saying a quo warranto, in essence.
I'm sorry, what?
A quo warranto. That is, in essence, the prerogative writ would be quo warranto. By what authority do you do this? And the answer to that is, you can't... The question was about administrative remedies. There is no administrative remedy. The Article 78 itself against the Department of Buildings is not an administrative remedy. It's a judicial remedy. The second question I believe that you asked is, well, I think the important point about that is, why would that prevent this action from being brought?
So it's because you're saying you're challenging on the face of the statute, right? It's a statutory challenge here. It's not an administrative, right? That's the long way of saying that's what we got.
That's exactly it. I'm saying that, look, we've cited the law, we've cited the sections, we've quoted it repeatedly, that these can be extended for a period of 2 years. The other question is, in regard to that, are we seeking a remedy against the Department of Buildings? And the answer is no. We're seeking a remedy against the building owner, against some very, very serious conditions. These are buildings that have been expanded, they've had floors
Well,
added.
implicitly you will be, because if we agree with you, that affects DOB, right? I mean, there can't be just one TCO out there. There's got to be a lot of TCOs out there that may have be or not in conformity with Section 304.4, right?
Well, I would guess that there are a great many things that the building department does that are not in compliance with law, and that is probably one of them. And, you know, again, the whole procedure here, I know the buildings department is grossly understaffed. I know they're underfunded. I know they have a very hard time of it. One of the thrusts through this, though, is that you have these TCOs that are granted because somebody sits down at a computer, not necessarily the architect, and just goes through it. There is no DOB inspection in here. And we have a motion for there's a motion for summary judgment now. The question is there a triable issue of fact? And we have an affidavit from an architect. We have two, I believe. There is no affidavit from an architect, just an expediter, on the part of the landlord. There is no proof that the Department of Buildings has ever investigated this. We have some very, very serious safety standards.
Why are we getting to those issues? I'm sort of wondering if your primary argument is that the Department of Buildings had no authority under the statute to extend the temporary certificate of occupancy beyond 2 years. And that's what the statute says. And if that's the legal issue that has to be determined, what does it matter what the Department of Buildings did or did not do, what shape the building's in? They didn't have the right, you're saying, the Department of Buildings, to grant that extended certificate of occupancy. If you win on that, we don't get to any of those other issues.
Well, that's correct. I'm saying it's a nullity. I'm saying that if they had authority granted for up to 2 years...
So if we accepted that argument, or some court accepted, we won't decide that today, but if that argument got accepted down the road, none of this other stuff would come into play, right?
That is probably correct.
Sir,
But if
could
you
you
accepted
point
the
to-
argument that...
Go ahead, finish your response. I'm sorry.
I was saying, if we accepted the argument that after, we're now in something like the 10th year of TCOs, that those were a nullity, yeah, you wouldn't reach it.
Could you identify a case, whether it's appellate or trial, where the propriety of the issuance by DOB of a temporary certificate of occupancy has been challenged in this manner?
I have not found, I searched, I have found one that neither upholds nor any that says that it is not. I have also not found any action or proceeding where somebody has brought an Article 78 against the Department of Buildings. As far as I know, it's an unlitigated point. And I see my time is up, and I would like to yield to Ms. Cruz unless the court has further questions.
Good afternoon, Your Honors. Magda Cruz for the owner, Kushner Village, 329 East and Westminster.
I have a question right away.
Yes, sir. Yes, ma'am, I'm sorry.
Your argument is that they were required to exhaust administrative remedies.
Yes,
But my understanding is the primary argument they're making is that the statute on its face is unambiguous. It clearly provides the Department of Buildings cannot extend a temporary certificate of occupancy for more than 2 years. Therefore, this temporary certificate is invalid, and there's no valid certificate of occupancy for the building. Why should that go to an Article 78 proceeding before the Department of Buildings, where the only issue is whether the Department of Buildings has the statutory authority to do something that's in violation of the unambiguous terms of the statute?
but the bottom line, Your Honor, is that there were the TCOs that were renewed, and
Right.
the owner has no control other than to make sure that it's doing what it has to do to meet those requirements.
Right, but if under the statute, the Department of Buildings does not have the authority to do what it did, because the statute says you can't extend it beyond 2 years, why can't a court make a determination, one way or another, whether those certificate of occupancies are valid or invalid as contrary to the express and unambiguous terms of the statute? Why is a court unable to make that determination without first going to the Department of Buildings or commencing an Article 78 proceeding?
Because this court, as well as others, have held that the court is bound by the determinations of the Department of Buildings with respect to TCOs and certificates of occupancy, even if...
What case has I haven't found any cases, and I don't know that there are any cases where the question is not, usually in an Article 78, the question is, did the department exercise their authority in a correct way? Did they use their judgment right? Did they look at the facts right? But the argument or discussion here has nothing to do with the factual dispute. There is no factual dispute, and there's no interpretation of a regulation. So why can't a court make a finding in this litigation whether or not the certificate of occupancies are invalid on the ground that they were extended beyond 2 years, which is contrary to the terms of the statute? What prohibits a court from making it without first having an administrative proceeding?
I would say to you that, firstly, your precedent, although you say that it's never been directly addressed, your precedent in different contexts of challenges to TCOs, not strictly the statutory compliance with the 2-year provision.
I'm sorry to interrupt, but did any of them, because this case is different, did any of them involve a case, any of these other precedents involve a case where an argument was made that the Department of Building exceeded their express statutory authority in making the determination about the C of O?
Well, not as far as the 2-year limitation, but the case I'm thinking of is Frank B. Hall and Company. It's discussed in my brief.
I'm familiar with that case. Okay. So isn't that a case where the Department of Buildings was, in fact, analyzing their analyzing their authority as to whether or not a certificate of occupancy should be extended? It had nothing to do with whether they were violating a statute or not.
Well, to the degree that in this case, you have a situation where renewals are being issued and the tenants are contesting that, there certainly is a process at the Department of Buildings to bring that according to the administrative code as well as the city charter, to have it reviewed first by the Board of Standards and Appeals.
But just so I understand, if the argument is an argument that there's no authority under the statute to do it, what kind of determinations would be made at the Board of Standards or any of these administrative steps that are anything other than interpreting whether the terms of this statute have been violated?
Because the administrative code at section 27-218 provides the Commissioner of Buildings with the discretion to renew a temporary C of O. So if it has this discretion, there cannot be a violation of law per
That
se.
Let me ask, I'm sorry, then you can ask. If that's true, and there's an actual conflict between the terms of the administrative code and the terms of the MDL, that the administrative code doesn't have any two-year limitation, and the MDL does have that limitation, wouldn't the MDL override any provision of the administrative code which allows an extension beyond 2 years?
I would submit under these circumstances where the essential element of the safety of the building is within the exclusive jurisdiction of the Department of Buildings, and the Department of Buildings has explicit discretion whether to issue a TCO or renew a TCO, I would submit that the MDL does not override that.
Let me ask one more question, and then I'm going to let my colleagues ask a question. If the statute says you can't extend it beyond 2 years, and there's no limitations in that statute, what discretion is there under the statute for the Department of Buildings to exercise or to consider where there's a clear, unlimited statement that it can't be extended beyond 2 years?
I mean, Your Honor, it is true that these TCOs, in many instances, not just in our buildings, have been renewed for greater than 2 years, and there are many different reasons why that is the case. And again, it is something that is within the jurisdiction of the Department of Buildings, not a matter for court intervention.
Well, do we have the
It has
right?
exclusive primary jurisdiction.
Don't we, as a court, have jurisdiction to decide whether an agency has exceeded its express statutory authority in the actions it's taking? Do
Definitely.
we have that jurisdiction?
Definitely, but not in the context of this type of class action in the first instance. You do have that discretion under Article 78, but not under this context where the case is brought against the property owner, not even naming the Department of Buildings. The property owner is simply complying with what it believes to be a properly issued temporary C of O. It is doing what the Department of Buildings has said it can do, and it is proceeding with its project in accordance with those requirements. The court should not have to intervene without, at the very least, the Department of Buildings being in the action.
Okay, go ahead, Justice Young, with your question.
Good.
Do you have any, does anyone else, since I know I've monopolized the time, does anyone else have any questions they want to ask on this? Okay, thank you very much.
Thank you.
Your Honors,
I just want to pick up on one quick point about the DOB. Counsel is saying that, what I hear is that DOB has to be involved in this. Do you agree or disagree? What's your response to that?
I disagree. I also very strongly disagree with saying that they have exclusive jurisdiction over building safety. There are at least 4 other agencies I can name off the top of my head, as well as the housing court, they have jurisdiction over.
Well, the way I look at it is the MDL versus the regs. The regs giving the commissioner full authority, right? That I don't think this case here is challenging that authority this discretionary authority to issue TCOs. But the way I look at it, if you harmonize MDL with the regs, MDL says, well, you can do whatever you want, but you got a cap of 2 years, right?
That's how I read the statute. And again, this case is ultimately about getting a mandatory injunction for building safety, and the whole case got thrown out. And we want, we want the conditions fixed regardless.
I'm looking at a bigger picture. This case is simply asking us whether or not your claim, your cause of action should go to the administrative level first, or can it come to the court first? That's it. I mean, everything else goes down the road because you didn't move for summary judgment on your first cause of action. You right? You're only seeking class certification.
Correct.
So that's where, so if I would agree with you, it's you got to keep going with this, right? I mean, in terms of your arguments.
A, we got to keep going, and B, this court may very well decide that, no, you can't attack the C of O collaterally without bringing in the Department of Buildings, either implead them, do whatever you have to do, third-party practice. But the other hand, getting a mandatory injunction requiring the owner to put in the sprinklers. We're now in the 10th year of this building having these 4 buildings having extra stories added, extra tenant loads, without the building being sprinkled, which is a specific requirement from the Board of Standards of Appeals to grant permission for this work.
What's your response saying that, you know, you're going after the landlord? The landlord is just following what the DOB says it could do. So why are you attacking the landlord?
I'm attacking the landlord because the landlord has a non-delegable duty to keep the building in proper repair and make it safe. And right now, these are not safe buildings. They are not. If this building had a fire, people would die in it. This is not a minor situation. You've increased the percentage 25% in terms of occupancy of the building. You're required to have a sprinkler to do that according to standards and appeals, and it's not there.
Thank you very much.
Thank you.
People versus Higgs.
Good afternoon, Your Honors. Paris DeYoung of the Legal Aid Society, here on behalf of appellant Mr. Anthony Higgs. In no way diminishing the severity of the underlying offense in this case, for an individual with no prior criminal history who displayed exemplary behavior in the 2 years he was out on bail and at liberty pending sentence, we believe imposing the maximum PRS term here was excessive. Under the ABA standards, the sentence imposed should be no more severe than necessary to achieve the societal purposes for which it is authorized. And I submit to Your Honors today, a 5-year, again, the maximum PRS term is far longer than necessary to achieve any of these societal goals under the very unique circumstances.
How does the fact that we have now the statute that's already been out there, the less is more statute, affect your PRS argument? Because, right, I mean, these applications to reduce the PRS, they will automatically happen if certain milestones are hit by the defendant, right? They're automatically reduced. So why, I mean, he got 5 years PRS. He may not even have to serve the full 5 years of PRS. So how does the statute affect your argument before us?
Yes, Your Honor. So as you've said, less is more does apply to PRS, but the legislature in passing that act did in no way curtail this court's power to, in the first instance, reduce as excessive. In any event—
How long has he been on PRS now?
17 months, Your Honor.
17 months, okay.
Yes. But in any event, it was a 5-year term, and if he were to be completely successful under less is more, he'd be looking at 2.5 years. And right. What the legislature in passing the act actually highlighted was that after the first year of supervision, the benefits of supervision start to be outweighed by the infringement on one's liberty interest. And I think in this case, given his incredible behavior while he was out on bail and the other factors that I will get into, 2.5 years, even if is still a significant amount of time.
I'm not shirking our responsibility, but there are processes by which, you know, the legislature have saw fit to allow individuals to go V4 and seek reductions before even coming up here. I mean, I'm not saying we shouldn't do that, but there are opportunities that we don't know what's in the record, and you're asking us to do something without us having, you know, what's going on, correct? Well, I'm looking at a stale record in a sense, right?
It's
I don't know what happened since he's been on PRS. I'm just thinking out of the
certainly,
box.
And it would be outside the record for me to discuss how he is doing on PRS. But I think his record before he was ever incarcerated was so exceptional, we all could probably infer. But I would like to just briefly address 2 things that I think in this case are really stand out. And I also want to highlight that my opponent failed to address these 2 factors in his response. He had nothing whatsoever to say, and I think that is something that you all should be paying attention to. The first is that he did have a completely exemplary record in the 2 years that he was out on bail. Not only did he get a full-time job, he also got a part-time job in the evenings. He also enrolled himself in a 12-week anger management class so he could learn his triggers and make sure that this type of crime never happened again. But I think the most important thing that happened in this case that really makes it stand apart is that The prosecution, on the record at the plea hearing, took the unusual step of allowing my client to remain at liberty pending sentencing. Your Honors, if the prosecution saw no benefit in having my client supervised in the months between his plea and his sentence, it is hard to imagine why the imposition of a 5-year PRS term after the fact would be necessary, especially now that he has successfully completed 5 years in prison and 17 months on PRS. Again, Your Honors, I acknowledge that my client's actions here were reprehensible. They were deserving of punishment. But it is this court's obligation to consider all the societal benefits that come with PRS and what the minimum sentence necessary is to accomplish those goals. And I think in light of all he has demonstrated, and mainly that he doesn't need supervision to avoid criminal behavior or to successfully reintegrate into the community, the amount of time, which would be the minimum here, 2.5, would be more than sufficient to meet those aims. Thank you.
Good afternoon, Your Honors. Andrew Loizides for the respondent, the Office of Darcel Clark. It may please the court. Your Honors, considering going into the defendant's egregious crime here, the fact that he broke into his ex-girlfriend's apartment, tied her down, beat her, choked her, dragged her by her legs, poured bleach onto her clothes, all while...
Counsel, but your office still saw fit to leave him at liberty, right? During the course of this case and during the course of after he had pled guilty, right?
That's correct, Your Honor, yes. They allowed him to remain out on bail for this, in which, you know, considering the fact that if he violated his terms of bail, then he would immediately be thrown into jail. So it was within his interest to be on his best behavior while he was pending sentence in this case. But the fact that he did this and the fact that he only received 5 years imprisonment and 5 years post-release supervision is a lenient sentence. And while he completed his prison sentence, he's now on post-release supervision. This is in no way excessive. Yes, it's as Your Honor pointed out, less is more could be applicable in this case, and if he continues to do what he is supposed to do in meeting the terms of his probation, perhaps it will be reduced. But again, considering what he did, we're not convinced that just 5 years is excessive in this case. I think that if he just continues to do what he's supposed to do, then perhaps it could be reduced on his own time, but not at this moment. Unless Your Honors have any questions for me, then I respectfully submit based on my arguments laid out in our brief.
Thank you.
Your Honors, I will be brief. I am unsurprised by my opponent's arguments here. Yes, the underlying actions here were deplorable, deserving of punishment. That is one factor that this court is to consider when evaluating an excessive sentence claim. Again, the other primary
Counsel,
thing...
I'm not sure that that's entirely your adversary's argument. What he's saying is that your clients already received the benefit. So there should be no further benefits extended to your client.
So... Yes, Your Honors. Obviously, the bargain for nature of a plea agreement is something that this court can consider in evaluating the excessiveness of a claim. However, I think my opponent's reliance on it is frankly a bit misguided. The Ba court made very clear this is not a dispositive factor. There are other factors that deserve just as much, if not more weight. And in any event, in the Ba case, which again, my opponent relies very heavily...
What factor here do you think deserves more weight than the fact of the nature of the crime versus the punishment that he received being much less?
I think the factor that deserves the most analysis here is what trying to meet the societal aims of post-release supervision and evaluating my client's history and looking at, okay, he was always successful even without supervision for 2 years. So when we go back to that sentencing standard that says, what is the minimum sentence necessary to accomplish the aims that we have for this type of punishment? And when we have all the evidence before us that he doesn't need supervision to avoid criminal
Justice Kern, may I just pose a question? I'll be very brief, because I know you talk about various mitigating factors, you know,
Yes.
lack of criminal history, work experience, but didn't the court have this information before it?
Absolutely, Your Honor. I mean, but in order to adopt the proposition, and my opponent does bring it up, that these factors simply, because they were before the trial court, somehow limits this court's power to reduce sentences as excessive, would eliminate this court's power to reduce sentences as excessive. We're on direct appeal. We're limited to what was known before the trial court in presenting this case to you. I also want to highlight in People v. Ba,
No highlighting. Answering the question.
I just have one quick question. There's no order of protection involved in this case, right? Your client didn't have an order of protection for it.
At the time of the offense?
know after all this as part of the plea that there was an order of protection put in place?
I believe there was an order of protection,
Was?
yes.
Okay.
Thank you very much.
Thank you.
Mercer Square versus Namdor.
Good afternoon, Your Honors. Hal Bierman, Greenberg Trarg, on behalf of defendants, appellants, respondents, Namdor Inc., and Gristedes Food Inc. May it please the Court. Supreme Court incorrectly denied Namdor's motion for summary judgment on its counterclaim for constructive eviction. There are two issues with respect to its claim. One, was the presence of toxic mold resulting from a defective and leaking roof sufficient reason for the tenant to vacate the premises? And two, was the landlord provided sufficient notice of the defective condition? On the first point, the record is replete with evidence that the roof was defective and there were dangerous levels of toxic mold in the premises. The August 1st, 2018 New York State Health Inspection Report, which found mold in the premises. The August 11th,
Wasn't there, at a minimum, a disputed issue of fact about who was responsible for repairing the conditions which created the mold in the first instance?
No, Your Honor. There is no question of fact that the roof is the landlord's responsibility. And the
Isn't the landlord's claim that in fact this happened because of problems with the HVAC system, which were the tenant's responsibility, which was not addressed?
Your Honor, in response to the evidence presented on the motion for summary judgment, which includes expert reports, affidavits, personal observations, and everything else that's in the record, the landlord has come back with nothing. All of that evidence is unrefuted. The only thing presented in the record before this court from the landlord's side is an affirmation of counsel, an affidavit attesting to a rent roll, and the affidavit of principal that barely mentions the roof. So without having any opposition evidence to what occurred, and again, the record, the photographs, the expert reports are all unrebutted.
Let me ask you another question. Putting that aside, what about, isn't there also a disputed issue of fact about whether this is a type of condition that would be sufficient to require the tenant to vacate the premises?
Your Honor, the idea that mold spores, the expert report we presented shows that the ambient outside mold spores were about 500 per cubic square meter. Inside the premises, 100,000 mold spores.
But
The idea
didn't
that
you
mold...
move out before you even gave the landlord any chance to remedy or cure or do anything with respect to the...
Absolutely, and that's
So couldn't
exactly...
have been something that could have been I mean, you didn't even know at the time you moved out the tenant. The tenant just moved out.
Your Honor, at the time we moved out, there was no question that there was an issue with the premises. And when we moved out, we vacated August 31st. At the time we vacated, had we said we're vacating because we're constructively evicted, the landlord would have a point. It's not what happened. What happened was we vacated to protect the safety and the health of our customers and our employees. And once we got out, we reached out to the landlord. We emailed, we communicated, we met with the landlord in October. We sat down with the landlord and said, landlord, you have to fix this defective roof. There's rain, there's tiles falling down from the floor because the roof is leaking so badly. And the landlord responded, why would I do that? I'm just gonna raise the building and renovate it for another tenant after your lease is over. So at that point, the tenant had no choice but to assert its constructive eviction rights. And it wasn't until December, 3 months after it vacated, and
Counsel,
gave
this
landlord
discussion occurred in an email. It's in the record.
I'm sorry?
Did this discussion that you're talking about
Yes.
occurred?
Yes, Your Honor. There's the affidavits, there's the emails, there's the affidavit of Charles D'Amico that discusses the meeting and the landlord's response at that meeting. There's the expert reports that also show all this occurring. So, Your Honor, what else was the tenant to do? What else were they to do? They could not stay another minute and subject their employees and their customers to this condition.
But you'd already moved out. I'm sorry.
We moved out August 31st, but we didn't say we weren't coming back. Why would we reach out to the landlord? Why would we sit there and have a meeting in October and say, fix the roof, please?
Just want to go back because there were problems with the premises even before August, July of that year, 2018. There were issues then.
Yeah, we didn't know at the time, Your Honor. We didn't know until we retained an expert as to exactly what the problem was. It wasn't until AESI came in and did an analysis and did the mold test and looked at the roof and saw the leaks, the spalling, the pooling, et cetera, that we found out that the roof was really the base cause of the issues in the premises.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Jerry Weiss, and I represent the respondent cross-appellant Mercer Square in this matter. Your Honors, just to clear up the record, as this Court has recognized immediately before, Ms. Flores, who is the Executive Vice President in July 2018, already recognized at the time that this premises was not habitable. She says, I must say, I am embarrassed and ashamed that the Gristides name hangs above number 508. Mortified is a better word. No wonder no one shops here. That's at page 1226 of the record. So for then Ms. Flores to come and say that this problem, or for, I should say for appellant to say that this problem only started in August Your Honor, I must say that that is not consistent with the record.
And if I can just continue from there, I think there was some discussion about granting certain rent concessions.
Yes, Your Honor.
And then when the landlord did not do that, then we're abandoning the premises August 31st.
That is precisely the case, Your Honor. The only written notice that we got was in December. That's when they decided to tell us that they officially, now it's true that we, as early as October, already had our discussions, but they found out about this problem August 21st. They had an inspection, and by August 31st, they were gone. We didn't meet them till October 3rd. To be clear, Your Honors, they notified their customers, they notified their vendors, they notified their employees. There is nothing in the record that suggests that there is a single complaint, a single incident report, a single photograph that shows any of the conditions that are alleged to create the mold. And so we're clear, the mold itself is a bit of a red herring because the landlord is not contesting whether or not mold existed in the premises. There may very well have been mold there, and likely was, given what Ms. Flores herself says. The issue is whether or not it is the roof that created that mold condition. And there is nothing in the record, there isn't a single photograph of the underside of the roof which would show that there is, in fact, a leak coming in there. That does not exist in the record. So there is nothing in the record that substantiates the fact that there is a leak. There is evidence in the record that suggests that there is an HVAC problem. And Your Honors, as far as the concept of notice, as Justice Kern recognized, the landlord is entitled under the precedent set forth in this court, landlord is entitled to the opportunity to cure a particular problem before a tenant has the right to simply vacate. The notion that the tenant vacated in August but did not claim a constructive eviction until December, that's not consistent. If in fact the tenant vacated, and if I may just complete my answer, if the tenant vacated without a basis in August, then the tenant is in violation of its lease for abandoning the premises. That in and of itself is a violation of the lease. To say that it was looking to protect its customers and it was looking to protect its employees without giving the landlord notice has deprived the landlord of its opportunity to in fact investigate and correct the problem if necessary. Thank you, Your Honors.
Your Honor, counsel would have Gristides keep its grocery store open to the public and occupy it while it's knowledgeable about a dangerous mold condition. That's absurd. And constructive eviction cannot be a use it or lose it defense. They left the property, albeit they were trying to do so temporarily. Otherwise, why try to reach out to the landlord September 5th, September 7th, September 13th? The landlord kept putting them off. That's why the meeting didn't occur until October. As far as the evidence of the roof leakage, there's testimony in the record, unrebutted. Jeffrey Anderson, landlord's environmental expert, who concluded the probable and primary cause of toxic mold growth in the premises was leaks from the roof. The
Counsel,
testimony.
I gotta correct you on one thing. I see in the record here, page 196, that there is a document from an inspection of the roof that says that the leak was coming from the AC unit.
Well, on 196?
Yeah,
Your Honor, I believe that is.
that was October
I
5th.
believe that is a report that is attached to an affidavit of the landlord's principal. It is hearsay upon hearsay. There's no authentication of it. There's nothing to suggest that that report is accurate in any respect.
This is raising a factual issue, right?
No, Your Honor, it's not, because the Court of Appeals has made clear the only thing that can rebut and create a factual issue is admissible evidence. This is not admissible evidence. But in response to the testimony of Mr. Anderson, the testimony of Ms. Hackle, who said highly likely that the mold growth in the premises was caused by leaks from the roof, the ESI report itself, the proposal for environmental services that said the mold abatement could be done in 2 weeks if the roof was fixed. Well, the tenant was trying to get that done, and the landlord refused. Until, of course, the end of the lease is over, and then they replace the building. And they replace the building without giving us an opportunity to have our testifying expert look at it, which is why the spoliation issue should also should grant tenant summary judgment. Thank you.
Your Honors, the notion that the tenant was trying to get the problem fixed is not consistent with the record either. If the tenant was trying to get the problem fixed, the tenant would have provided the landlord with the notice that it needed. If the landlord, if the mold problem could have been resolved as the tenant was so concerned, then the tenant could have resolved the mold problem and then dealt with whether or not it was the landlord's responsibility to correct it or not at a later point. The fact remains that this tenant was an opportunistic tenant who was looking to strong-arm the landlord to make various concessions to the tenant before the tenant would agree to extend its lease. And the landlord simply would not allow itself to be strong-armed, and therefore the tenant took opportunistic advantage of a New York State the New York State inspection report, which shows the presence of mold in tenant's refrigeration system or in tenant's display case. Thank you, Your Honors.
Thank you. DMR Plumbing versus City of New York.
Good morning, Your Honors. May it please the court. My name is Gil Perez. I appear for DMR Plumbing as the appellant. In the proceeding below, we felt that the court got the procedure incorrectly in that it basically questioned all of our assertions of fact in the petition, and it essentially dismissed the petition on a motion to dismiss without an answer. Had we received an answer and had we received a record, the record would have demonstrated, one, that our case really was futile, that we were before the Office of Administrative Trials and Hearings seeking discovery, and the city simply sought to submit their answer.
The exhaustion issue, that the argument that you had to go and finish that administrative hearing before you could come to court and challenge it. And instead, your client defaulted, never finished the hearing, and then paid the fines. Why isn't that foreclose your ability to come to court and challenge what happened at the administrative hearing?
Default is exhibited by a default notice, which was never produced. The default notice was after the order to show cause was signed. That is item one. Item two, we then paid the default penalty because to not pay the default penalty, the plumber would have had to close his shop at renewal and not be able to employ the 234 people he employed. The penalty was $1,200.
Go ahead. Yeah, are you done? Okay, thank you.
Good afternoon, Your Honors. My name is Amanda Abata, and I represent the respondents here. I just have to begin by clarifying just a few points from my opponents. First of all, the fines were $8,000. Second of all, the plumbing company defaulted on the last day of hearing, which was approximately, well, first of all, they attended a few hearings, prematurely filed this Article 78 proceeding, a few days before the final day of the hearing. They then defaulted at the hearing, and on the day that they defaulted, that's when the penalties were imposed. It was after that that their order to show cause was signed, and the order to show cause granted them a stay of enforcement. Despite this stay of enforcement, they then elected to pay the penalties. And that payment of the penalties essentially forecloses this whole sort of appeal and renders this matter essentially moot. With regards to the payment of the penalty was an admission of liability, and my adversary says a lot of things here for the first time that were not stated in his brief. For example, all of this talk about the payment being a necessity for the plumbing company to continue to operate has not been raised prior to this very moment. In fact, in the brief, DeMar concedes that they pay the penalty, but they do so under protest, quote unquote, because Oath and DOB ignored the state of enforcement, which, as we've discussed, there was no stay of enforcement in place when the hearing officer imposed the penalties. And when DeMar paid the penalties, there was one that they just elected to forego. With regards independently of that, they failed to exhaust their administrative remedies. There's two paths available to DeMar to initiate an Article 78 proceeding here. One, they could have appealed an unfavorable decision from the hearing officer to the Oath's appeals unit and gotten a final administrative decision, or they could have requested and received a denial for a new hearing after default. They received neither. Instead, 3 days before Oath issued a decision, they prematurely brought this Article 78, saying that DOB failed to produce discovery and that the Oath process was allegedly compromised.
Counsel, is there any evidence that exhausting all of their remedies would have been futile?
No, Your Honor, because there was no definitive statement of position from DOB that would have given them that indication. In fact, the reason DOB was ready to proceed on the penultimate hearing date, which was in the October 22 hearing date, it was DeMar that requested an adjournment to obtain additional information. So really, that final hearing date was for them. So there was no evidence here that continuing to proceed with the hearing or exhausting all the administrative remedies would have been futile. And finally, I just want to touch briefly on this alleged bias that they raised for the first time, in their appellate brief. Although it's not properly before the court, to establish bias, DeMar had to show record support, one, for the alleged bias, and that the outcome flowed from the bias. Again, they did neither. They argue that it was evident, that the bias was evident in terms of the adjournments that Oath granted, which condoned DOB's discovery misconduct. But there's no record evidence that the hearing officer ordered DOB to produce additional discovery, much less that DOB ignored that order. And the record shows that DeMar consented to all of DOB's adjournment requests. And to the second prong of that bias analysis, the outcome of this case flowed directly from three of DeMar's choices. One, not to appear on the final hearing date. Two, not to request a new hearing after they defaulted. And three, to voluntarily pay the fees that Oath imposed when they defaulted. None of these actions have anything to do with Oath's alleged bias during these hearings. So if there are no other questions, I'll rest on my brief, and we ask that this court affirm. Thank you.
Again, Your Honors, the failure of the city to produce the record or answer deprives the appellant the opportunity to demonstrate from the record and the actual documents that, one, it was futile, two, we definitely asked for discovery, three, that the hearing officer below, in 5 separate hearings, ordered discovery, and that the city didn't produce it. And in this instance, the city didn't produce the discovery simply because without discovery, the only evidence was the issuing officer's summons, which, in Oath rules, the hearing officer had to accept as true. It was futile. And if you have any further questions, I'd be happy to answer them.
Thank you very much. LW Holco versus Pools.
Good afternoon, Your Honors, and may it please the Court. My name is Scott Danner, and I represent the respondent, LW. I'll be very brief. I expect the irony won't be lost on the Court, but given Mr. Poles' absence here today, I just need to point it out. We are here on Mr. Poles' appeal from an order striking his answer for repeated and conceded violations of the CPLR and Justice Reed's discovery orders in the court below. That motion was granted.
Can't appeal an order granted on default.
Excuse me, Your Honor?
Can't appeal an order granted on default.
Precisely, Your Honor. Thank you. And
Anytime.
that order was entered on default after Mr. Poles failed to appear for the hearing on the motion and failed to submit any opposition.
So you're basically saying he failed to come today, he's been failing to come, and we should take that into account.
Your Honors were already there. I needn't have stood up. Thank you very much.
Thank you. Carl versus Julian.
Good afternoon, Your Honors. Richard Hirschfeld for appellant.
Wait, just let him
Sorry.
be seated first.
Richard Hirschfeld for appellant. As the court can probably see, this was a custody visitation hearing out of control. You had 26 orders to show cause. You had 39 appearances over.
Let me ask you a very specific question.
Sure.
There was a very long proceeding below that took many, many days. And obviously, the judge is no longer on the bench, so we can't send it back to the judge to just actually write a decision. So the choices are either to have a whole new trial, or for this court to look at the record, which is extensive, and look at the transcripts, and make our own determinations as to, first, the primary argument, whether there has been any domestic violence, and if so, whether that, what impact that has on the litigation. Why can't this court use its authority under these circumstances where we can't remand it back to the judge who was there to look at the record ourselves and make a decision based on the record, whether, because the court did issue a decision, whether that sparse decision was supported by the record in this case, rather than sending it down to a new judge for a new hearing after 19 days.
The problem, Judge, is that you have an inadequate record for a number of reasons. First of all,
Wasn't there a full hearing now?
it was a full hearing. It was a full hearing that lasted 6 years with no updated forensics, with no Lincoln hearing, with ineffective assistance of counsel on behalf of my client. As you can see in my reply, one of the big issues, and no discussion or findings on domestic violence. There was proof that my client had specific proof of domestic violence by the father. She had texts, she had recordings.
Right, but the court did make a determination ultimately that the father should get custody. Why can't this court look at the record and make an independent determination whether the record, as created below, did or did not support a finding of domestic violence, and if it did, whether or not it would change the outcome, and whether or not it was appropriate for the court to award custody to the father without remanding it?
Because you don't have an adequate record when the evidence of domestic violence was barred from the hearing. First of all, one of her first sets of attorneys never even tried to get in this information through her, which would have been clearly admissible. Her later on set of attorneys tried to get it in through the father, who acknowledged it was his phone number on the texts, but the court said he didn't remember whether he signed it or not, and the court concluded that was an inadequate foundation to allow it in, which, as you can see from my brief, is clearly not the case. As long as you've got a matching number, that's enough to get it in, and it's up to the trier of fact to give it whatever weight it thinks appropriate. So you don't have any of this information regarding domestic violence or drug abuse in the record. So how is the court going to make a determination?
What's the law about, I mean, I've seen a lot of ineffective counsel arguments in criminal cases. I don't think I've ever encountered that argument in a civil case, if that's a basis.
Especially where there were so many attorneys.
Well, there were so many attorneys, but you have an absolute right to counsel in a custody hearing. There are any number of cases where
That's
She had
correct.
counsel.
I'm sorry?
She had counsel.
Multiple
Many
counsels.
Counsel presumes a right to effective assistance of counsel. If you have a counsel who doesn't know what they're doing, and the middle attorney admitted she had no experience in matrimonial law.
And this was an attorney hired by your client, though, right?
She was
Retained.
she was pro bono after she had no funds because of the scorched earth motion practice that the father's attorneys proceeded with. And in any event, whether she had experience or not, she either defaulted or didn't get notice. The court never explored it on the ultimate motion that changed interim custody to the father. And the reason that he got interim custody, the court had held no hearing, made no effort to see where counsel was, where appellant was, just proceeded, okay, they're not here, interim custody has changed. And not only did he change interim custody, this was a mother who is the full-time caretaker of the child. She's relegated to supervised visitation of 2 days a week. How do you get from there to there without even making an inquiry as to where anybody is, without even holding a hearing about what's going on? And that order has essentially stayed in place through today. She gets 1 or 2 days a week. She can't afford 2 days of supervised visitation. The grandparents are completely excluded from contact with their granddaughter. And this is the granddaughter, the child is now 8, I believe. The litigation went on for 6 years. The order was in 2019. So you've got 5 years with no contact with the grandparents, with 1 day a week under supervised settings with the mother, where by the time the court issued its decision, you had reports from the supervising agency telling the court how great everything was going, how much the child and the mother got along together, how much the child wanted to see the mother more than in these extremely limited circumstances. So I don't see how.
Counsel, in that time.
And you don't have anything
Counsel?
updated hearing.
She's trying to answer your question.
I'm sorry.
I'm over here. In that time that there was supervised visitation, your client, of course, has availed herself of those visits, right?
Sometimes yes, sometimes no. It was a money issue. And she repeatedly told them it was a money issue. And if you look at my brief, where you've got an indigent parent and a moneyed parent, it's incumbent on the court to place the burden of that supervision on the cost of that supervision on the moneyed parent. The court didn't do that. So while
Thank you. Thank you. You have time to rebuttal.
Good afternoon. May it please the court.
Let me ask you something. What do we do with this situation where the court clearly did not issue a full decision, did not really make any findings of fact? The judge is no longer on the bench. And we have a case, Michael R. versus Pamela G., which requires the court below to make findings as, and not just a case, a statute. The law requires the court to make findings as to whether there was domestic violence, and if so, whether that, what effect that had on the custody determination. We don't have any of those findings. So what do we do in that circumstance?
As Your Honor had suggested during the prior argument, this court has as broad authority in custody matters as the family court. And if necessary, this court can conduct its own independent review of the evidence and make findings. And here, where there is a sound and substantial basis in the record, the court should not remand and should instead affirm.
Counsel, how do you deal with your adversary's argument that there are things not in the record that the court would need in order, this court would need in order to make the determinations?
This case was litigated. It's now going on approximately 7 years. And I say it's still going on because since the decision was issued in October of 2022, there's still been substantial litigation. Counsel said that the child hasn't seen her maternal grandparents in years. That's simply false. The grandparents have made numerous petitions for visitation. My client has consented, and in fact, for years, the grandparents were also having regular supervision with the child. The court eventually, within the past year, dismissed their latest petition that they brought, after which my client offered them voluntarily to have visits, but then they refused because they wanted multiple visits each week, and my client had said that's simply too onerous for the child's schedule. But he actually offered. In fact, my client is the one who is still promoting a relationship with the appellant's family.
So the gist of it is that this record is so complete that we have more than ample information to make determinations.
It is. I would argue that it is beyond complete. There was so much that had happened in the 5 years of litigation until there was the decision at trial, and even since then. I'll note that the mother has also recently filed a modification petition. That case was actually before the family court today on the mother's modification petition. And so the mother is seeking to modify.
But that's not before us, right?
Correct.
That's not in our record, right?
It's not, no,
Okay.
but she filed a modification petition, and that was heard today, this morning before the family court, and it was adjourned to.
Putting aside that, that's not on the record, but what we do have in front of it, for my purposes, is we have a 19-day hearing where this appeal is really focused on, right? I mean, and in those 19 days, I would gather, I mean, there's a lot going on in that transcript.
There's a ton, Your
Yeah,
Honor. There's a
okay.
ton that went on during this trial. There is so much evidence. And as far as the domestic violence goes, it's clear from the record that Judge Richardson dismissed all of the mother's claims about domestic violence. And I'll note that while the court's required to consider the mother's claims, it's not required to credit them. And the court clearly did not credit the mother.
And what are you basing that argument on? That statement on?
The fact that the judge even stated on the record that there was no proof of any of the mother's abuse allegations other than the fact that the father had been arrested 5 times. And then the court went on to note that the mother was the one who called the police and had the father arrested 5 times. That the court specifically stated that there was no other evidence other than the mother's baseless claims and baseless conclusions. So this is a situation where the court certainly considered all of the mother's allegations, but the court found that the mother had no credibility because she didn't. She had 0 credibility, and that's clear from the record. And
Sir, how do you respond to your friend's point that there were instances of ineffective assistance of counsel?
11 attorneys. The mother had 11 attorneys from the start of the litigation up through the end of trial. It's not counting things that have happened since October of 2022 when the judge issued his final decision. 11 different attorneys, some of the most preeminent family law attorneys in New York City, who the mother herself retained, and they represented her throughout that entire period. Now, the fact that she went through so many different attorneys and so many attorneys made motions to be relieved from her representation because, as the attorneys even wrote in their motions, she wouldn't listen to their advice. She insisted on making arguments that they could not ethically stand up and make. There was so much that had gone on. This is...
Okay, let's hear from the attorney.
I apologize. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. My name is Diane Pizarro. I represent the child in this case. With respect to the domestic violence issue in this case, I certainly wish that Judge Richardson's decision had mentioned it explicitly. It did not, but his decision did make clear that he weighed the evidence, he sifted through it, he weighed the credibility, and he made his finding.
But that omission, the fact that Judge Richardson didn't have a chance, because he did say, I'm going to put it in writing, and then he retired.
That's right.
So that the fact that that didn't get done, we have case law here. I found case law, I mean, Michael R., and then the citations to the Second Department, that we ourselves have the authority to,
That's right, Your Honor. That's right.
review the record.
That's right, Your Honor. And what I was going to say about that is, I mentioned a couple of times in my brief that the court was well aware of this issue. The mother brought it up in her testimony extensively, in her written submissions extensively. It was front and center. The judge mentioned it early on. He said that two issues before the court were the father's drug and alcohol use and the domestic violence issue. There was another time where the judge was responding to a written motion, and he commented that he was aware of the allegations the mother had said, but then he commented about his own observations of the father in court, the father's demeanor, the father's disposition, and said that nothing that he had observed comported with what the mother reported. And then there was the time related to the transfer of the child full-time to the father's care, where the mother's attorney said that the father was a violent abuser, and the judge said, where's the evidence of that? Now, I would just like briefly to go to the precipitating event that led to the transfer of the child full-time from the mother to the father. At that time, the father already was getting extensive visitation. Judge Richardson very carefully monitored this family, kept track of how the visits were going, received regular reports. I believe the father was up to 3 nights a week of visitation when the transfer happened. And contrary to what the appellant's attorney has argued here, the court did not make that transfer without inquiry. What happened was there was an allegation that a false allegation of sexual and physical abuse was lodged against the father. The court inquired of the attorneys. The mother's attorney confirmed that she did not herself pick up the call and file the report, but she was a source of the report. And then the mother's attorney urged the court, the family court, to review audio and video evidence, and when the court did so, the court said it was perfectly clear that the mother and the grandmother were coaching this child to make these allegations against the father. And so the transfer happened. It was well supported. The court had ample information, and the child has since lived with the father and is doing very well.
Thank you very much.
Thank you very much.
Couple of quick points, please. In terms of whether this should go back or not, first off, if I'm not mistaken, the attorney for the child agrees that it should go back for a new parenting schedule. So if nothing else, there's agreement between myself and the attorney for the child on that. Second of all, in terms of whether this record is complete or not, my client last testified June 11, 2019. The final order was 2022. As the court noted, there's a lot going on in between. My client never had an opportunity to address all of that going on in between. There was a motion to re-argue, to introduce other testimony, other witnesses. I don't even believe the court addressed the motion. I think it just was left lying there. So where you've got that 3-year gap between the last time my client had to speak to these issues and the time the judge ultimately decided the case, I don't think you've got a sufficient record in any event to make that determination. I would also point out that many of the transcripts—
This is your last sentence. You need to wrap
Sorry?
it up. You need to wrap it up. Your time's up.
Oh.
You need to wrap it up.
Okay.
You can finish your last sentence.
Okay, there are multiple transcripts which are virtually unreadable, so I don't know how you make a determination on a record with unreasonable transcripts where you've got no ability to go back and reconstruct it, because my client's attorneys, who knows where they are at this point, they wouldn't respond to me. I don't think you can get that information.
Thank you.
Okay.
No more. You don't get another round. No, we're aware of that. We've read the briefs. Yes. Board of Managers versus JMA Consultants.
Good afternoon. May it please the court. I'm Annette Hassapidis, appearing for the plaintiff appellant here. The court erred in granting summary judgment. The court made 3 rulings in that regard. That JMA had not acted as the QE at the time of the collapse, that there was no evidence of JMA's breach, and that plaintiff's expert opinion testimony was conclusory and did not raise any questions of fact. First, JMA was serving as the QE at the time of the collapse. And what do we have to rely upon there? The contract that JMA drafted itself that said that it was bound to comply with the rules of the City of New York, that it was being retained.
Talking about the fourth contract now?
I'm sorry, Your Honor?
You're talking about the fourth contract now?
Yes, the December 1, 2014 contract.
But isn't there evidence that fourth contract was not yet in effect or activated at the time that the incident occurred?
Well, that is what the court concluded, but the contract
What
did not
was
state that.
incorrect about that conclusion?
I'm sorry, Your Honor?
What was incorrect about that conclusion?
Well, first of all, the contract didn't say that. The contract said that the parties were bound by it upon signing and receiving payment. In the contract, JMA promised to serve as the QE. And further, there's a letter dated December 5th of 2014.
That's the fourth contract you're referring to when you made that statement?
Yes.
That's the
Yes,
fourth
Your Honor. And
contract.
if you look at
Because there were 4 contracts we're dealing with, right? There's 3, and then there's the dispositive one that everyone's
That's
looking
correct.
at.
And then there's also a letter of December 5th, 2014, 4 days after the QE contract, I'll call it, the fourth contract, where JMA points out they're essentially trying to sell the client on signing the contract. And at page 769 of the record, they explained to the board that if you sign on for the facade restoration proposal, the facade restoration work is needed so that the building can be classified as safe with a remediation and repair and maintenance program for the next cycle, SWARP, right? And at page 769, they're explaining to the board that the facade work under the earlier contract is needed essentially so that when the 8th cycle window opens, they can classify the
Hold on a
building.
second. But before the December 2014 agreement was signed by JMA,
Yes.
they couldn't, if my understanding is, they could only stand across the street and take pictures. They weren't allowed to actually go in and start digging in to see what the condition of the facade was.
Well, first of all, they had not asked for that. Secondly,
Well, not if they ask, it's in the contract, right? You don't have to ask for it. If the
Yes.
contract doesn't allow them to do it, it says this is what you have to do, they just follow the letter of the contract. I know what you said. You said
Yes.
they didn't ask for it. They didn't, why am I going to ask for something if the contract says this is what you do, A, B, C? Okay.
yes, but also...
And the contract was also clear that they weren't to do any physical probes.
That's correct, but they had already observed an unsafe condition under the EBES. In June of 2014, they said that there was visible wall movement. That
But that they needed to do a physical probe in order to get to it.
And that and under the EBES, that they were going to prioritize the work, and they promised to prioritize the work, and they did not do that. When they prepared the repair drawings, they did not call for probes in that area.
They could prioritize everything that you want them to do, but if they're not allowed to go in and do some boring, okay, that's an empty, that's, if contractually, if this is a breach of contract, that's all we have in front of us, contractually, they got a shield, I think, right?
Especially when the contract precludes them from doing that work that would highlight what the issues were.
But they identified the issues in June of 2014, a year and a half.
Okay, they
before- and
identified
our
it.
expert- I'm sorry.
Yes, they identified it, but by identifying and not doing anything, are they in breach? Of what contract are they in breach of then at that point? In June, that you said,
Yes.
that they identified it. That was before signing the contract in December. of
That's
2004,
correct.
Right? So if they identified it and they did nothing, what's the breach?
Not in June of 2014. When they signed the contract in December 2014,
Right.
they
You're
are...
doing a for you're arguing, and this is what Judge Cohen said, you're doing a retroactive liability then. You're trying to impose retroactive liability that you saw something in June, now we got you because you signed it in December, so you should have acted back then.
No, Your Honor, because...
That's what he said. That's what he was kind of saying.
No, because as you said, they were limited at that point. But once they signed that contract, it was their obligation
Yes.
to prioritize the work.
So
I want to go back, if I can. I want to go back. Let's talk about the June 2014 recommendation, right, of the probing. So my question is, did your client authorize that work to be done?
The probing?
Yes.
They never refused to allow them access. The evidence was clear that the board was
That's
never
not the
told...
question. That's not the question. The
I'm sorry.
question is, did you provide specific authorization, saying, all right, this is recommended, now you go do the work?
That was part of the December 2014
December,
contract.
later on, 6 months later.
That's correct. That's correct. And then when they undertook that affirmative obligation to serve as the QE and to supervise the repair and restoration work, it was their obligation when they to
Counsel, let me interrupt for a
prioritize
minute,
the
'cause
work.
You keep referring to that fourth contract.
Yes.
But what is incorrect about the statement that no work could commence under that fourth contract until the repair project mandated by Cycle 7 report had been completed? Because that's what the fourth contract says. At the time it was signed, that repair work had not yet been completed, so they couldn't begin the work yet, could they?
Well,
tell me what's wrong with that analysis.
Because you have to look at the both agreements together. The repair and restoration work was necessary to classify the building as swamp. They signed on as the QE in December of 2014 so that they could supervise that work, and when the cycle window opened in 2016, they'd be able to classify the window
At the
as...
time the incident occurred, they had not started their work yet under the fourth contract because the repair project hadn't been completed yet, right?
But they had, and the rules cannot...
They had started their work under the fourth contract?
Yes, they had, because they were supervising the swamp work at the time. You cannot construe the rules of the City of New York here to say that their obligations commenced when they decided to perform the critical examination. Judge Goying, I see you.
I just have one quick question. You know, the way I'm looking at it is that December 2014 contract, it would have been simple enough if exactly what you're saying, that you could have had their work that was done prior to December 2014 incorporated into that contract. You didn't do that. So that's their argument saying, and that's what Judge Cohen was saying. You're doing a retroactive situation where you're trying to hold someone liable for work that was done prior to this December 2014, but wasn't required until 2014.
But we're not, first of all, we're not saying that. What we're saying is that they were aware because they had performed the envelope building survey. Secondly, my client is the non-movement here, and you have to construe the agreements and the inferences from the agreements together. And doing that, you have to conclude that there are questions of fact whether they had an obligation. And even, Your Honor, I'll address this more.
You're both movements in this one. I got 2 motions for summary judgment.
Yes, but I'm only appealing the grant of summary judgment to JMA and not the denial of my client's cross motion. And I know I
have time on rebuttal. Thank you very much.
Good afternoon. May it please the court. John Visconti on behalf of respondents. I think you've preempted a lot of my arguments. What I would say is it was clear through the contracts that the repair project had to occur before critical inspections could happen for the FISP inspection cycle. The scaffolds weren't even all up yet at the time of the December 2014 contract, the fourth contract. So all the work couldn't be done.
What's wrong with our argument that your obligations began under that fourth contract the moment it was signed, not when the work began for the rest?
Because they couldn't perform critical inspections at that time without all the scaffolding being up. It was impossible to do so.
Correct me if I'm wrong, but when I read Supreme Court, when I read Judge Cohen's decision, it seemed like that their breach of the December 2014 is springing from an earlier events that they're trying to sort of put into the December 2014 contract.
Yes.
I mean, that's what he was saying. And he did, unless I had an out-of-body experience, he did say you're trying to do retroactive liability here. You're trying to do what they were supposed to do under the prior agreements, and now you're saying, well, you know what? I got you, because now you signed the December 2014 and you didn't finish it.
Right. So it assumes that JMA had identified an unsafe condition. If you look at the EBES report, there's red all over the place. There are a lot of deficiencies on the building, but not one of them, according to JMA, was any worse than the others. It was all things that had to be maintained and repaired, but they didn't look at the South Tower and say, oh my, that's coming down, we need to move now. There were 9 sections of the building identified as wall movement or possible wall movement. No,
following the contract. You're basically following it. I mean, there's no tort issue here. There is no more negligence. It's a straight up contract issue. And if you're following the letter of what the contract says you're supposed to do,
JMA did it. And if JMA had thought there was an unsafe condition, it would have reported it. It would have said, we got to get up there right now. But that's not what happened. There were a lot of
Well, you
things
could
that
because
needed to be
you weren't allowed to do a further inspection. So
That's right.
you could, because otherwise you'd be setting off alarm bell and you'd be sued for setting off an alarm bell that you shouldn't have.
The only way for JMA to determine whether any of those number 9's wall movement was worse than any other was to perform a probe and get up there, and the building didn't allow them to do it.
Thank you. Anything else?
Thank you. No.
I'd like to pivot to the straight breach of contract under the common law, and as we've spent a lot of time on the QE argument, JMA controlled when the scaffolding went up. JMA had control over it. They knew and were aware of the problem. Page 2389 of the record, Mr. Ferrara says...
How does that help you with the breach of contract if they control the scaffolding?
Well, he says we had a concern about the south facade, and that's why we put up a sidewalk bridge. Page 2389 of the record. So they know there's a problem. There's no evidence that they ever created any urgency here.
How's that a breach of contract? I'm trying to figure out, because I don't have a negligence claim anymore.
Right.
Okay, so what you're telling me all falls into like reasonable care, standard of reasonable care. It's a negligence issue, I think, right?
No, Your Honor. They failed to perform the work as required by a structural engineer. Our expert opinions were that because the bulging brick was visible from 300 feet away, it was their obligation, their ethical obligation, to make this an urgent...
Well, the duty then is springing from somewhere other than contract if it was an ethical obligation or a professional obligation.
Professional.
We're dealing solely with the breach of contract, as Justice Oing has stressed, and so we'll give you one more opportunity. Which specific contractual provision or provisions were breached when JMA, upon in deference to you and viewing the evidence in the light most favorable to you, upon seeing a dangerous condition, what contractual provision or provisions did it breach by not reporting that or taking some ameliorative action?
I'd refer the court to the agreement. It says that they are providing professional services under the agreement. It was their repair specifications and drawings that were being employed here, and the repair specifications were again based on the envelope building survey, and they had promised to, under this contract, to prioritize the work that was supposed to be performed. They did not prioritize any of the work.
Thank you very much.
Thank you.
People versus Blanding.
Good afternoon, Your Honors. My name is Stephen Berko, and I represent Appellant Clyde Blanding on behalf of the Legal Aid Society. Your Honors, the issue before this court is fully preserved by defense counsel's for-cause challenge to prospective juror Gitterman. Once counsel articulated the basis for the challenge, it was the trial judge's duty to ascertain from the prospective juror in unequivocal terms that she would render an impartial verdict solely based upon the evidence.
Well, the juror already indicated that she would.
She made equivocating statements, Your Honor.
There was nothing equivocating about her saying that I would make my decision based on the witness in front of me. I would not use my prior knowledge that I have about other rape cases. That's her direct language.
Then she went on to say, in a way that I think plausibly suggests that she negated the entire statement that she would render an unbiased verdict. She went on to say, in this particular case, I just felt it relevant. That's tantamount to saying, I still feel it relevant. And what we're maintaining to the court is that the trial judge at that point had a duty to ascertain whether she still was expressing a bias or whether she had walked away.
I think you're taking it a bit out of context, because after the court provided further instruction, that's when the prospective juror made that comment. But when you're talking now about further inquiry, my question is, did you, well, not you, but was there a request, after that was done to say, can we probe this further? Because I didn't see that happen.
Well, it's our position, Your Honor, that doesn't need to happen, and I would refer the court to People against Johnson, 17 New York 3rd at 752. It's a case relied upon by the people, and in that case, the court determined that given the absence of follow-up questioning by the trial court, after the juror expressed uncertainty concerning
But the juror here did not, just as my colleague said. She would focus on the evidence, and that prior statement, you're kind of taking it out of context. So here, there was no equivocation. So my question is, once that prospective juror was very clear about what she would do, was there any, further response? Can we get a further inquiry? Because I didn't see it.
Well, Your Honor, there are two issues here. Number one, you're assuming the conclusion that there was clarity.
I'm not assuming anything.
I think that the record supports the notion that she
Well, the judge found that there was clarity, and at that time, the defense counsel didn't say, note my objection for the record, or, Judge, I'm not clear, why don't we bring this prospective juror back in for further questioning?
Well, Your Honor, I think it could be plausibly argued that the statement, I found it relevant, it warrants further inquiry. Do you still find it relevant? I think that that is not the unequivocal expression of an unbiased
Well, no,
position.
at the end, I think defense counsel, look, this prospective juror, we all can agree, maybe have really was a little chatty, right? But at the end, defense counsel did ask her, so while we all have some general knowledge that we bring into any case, we can't presume certain facts that are not in evidence. You understand that? And the prospective juror responded, absolutely. And that was the end of that.
And then she went on to say, except the fact that I still find it relevant. So what we're saying is that it was incumbent upon the trial court to further question the jury, and we have People against Johnson for that proposition. We have this own court's decision in People against Ledesma at 204 AD 3rd 420, where there was no request by defense counsel for further questioning.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court, Connor Burns for the people. The trial judge did correctly deny defense counsel's for-cause challenge of the prospective juror. I think just at the outset, it's our position that these statements that she made did not cast a serious doubt on her ability to serve. And I think we need to take the statements in context. They were in response to the prosecutor's question. She had presented the jury with the fact that the victim here had made a subsequent false allegation and was probing the jury whether or not that they would be able to, in light of that, fairly evaluate her evidence. And she offered her opinion, which certainly isn't, there's nothing wrong. Just having an opinion in and of itself does not disqualify a juror. Jurors come in with life experiences. That certainly is to be expected. But I think it's also important that even during expressing her opinion, she says, I know this isn't evidence here in the case, but then goes on to express her opinion. Even if you disagree and think that her statements did cast doubt, I think the judge did engage in a further inquiry, and the juror certainly provided unequivocal assurances. She was quite clear with both the defense counsel and the judge that she would not presume facts and evidence. Even though she has this opinion, she understands that she cannot bring it into the courtroom and would have to make her decision based solely on the facts. And then just to address counsel's argument about that final statement that she made, that she felt her opinion was relevant, I think that was just simply to explain why she had offered her opinion in the first place. It certainly didn't undermine the assurances that she had just provided the court. And again, I was just explaining why she had offered that up in the first place. She obviously felt it was relevant.
So your reading of that last statement where she says, in this particular situation, just felt relevant, you don't read that as casting any doubt on her sort of unambiguous assurance that she would be fair, correct?
Certainly not. It certainly doesn't reaffirm.
So it takes it out of the realm of the case cited by your opponent.
Ledesma, is that your?
Yes.
Yes, certainly. It's a different situation than Ledesma. In Ledesma, that there are similar statements made by the juror in Ledesma and the juror here, although I believe they were a little more severe in Ledesma. But the critical difference in Ledesma is that when the judge did inquire, the juror there specifically did restate his opinion and said, I'm not sure I would be able to, I do my best to give both sides a fair trial. Here, the juror was very clear. She would be able to be fair. She would only presume the facts that were presented in the courtroom and would not bring her outside opinion in. And for those reasons, we do think that the trial judge was correct. And if there are no further questions, we ask you to affirm. Thank you.
Your Honors, briefly, I would just submit that the statement, "I just found it relevant," does not define the case outside the concerns that we have raised. I think in the ordinary way that people speak, that construction, "I just found it relevant," can also be interpreted as, "I still find it relevant and it warranted further questioning by the trial judge." And I would refer the court to the Court of Appeals decision in People Against Torpe, 63 New York 3rd at 69, an assurance of impartiality tempered with equivocation should not have been accepted by the trial court. I believe that's the circumstance that you have here, and I would ask the court to reverse.
Thank you. Mesha versus Pinar.
Good afternoon, Your Honors. May it please the court, Diana Lawless for the appellant defendant of the New York City Health and Hospitals Corporation. Supreme Court erred in denying HHC summary judgment. We have a lot of arguments in our brief about departure, but and I want to rely on those, but I want to focus my argument on proximate cause. The court found, rightly, and they don't really challenge, that we established our prima facie case on both the lack of a departure and the lack of a proximate cause. The court said there was a tribal issue of fact, but didn't address the proximate cause issue at all. Plaintiff expert offered no countering opinion on the standard of care for this.
Sorry, the what?
Sorry, I was talking about the standard of care. He didn't raise a tribal issue of fact regarding proximate cause, which is an independent basis for summary judgment. Because our expert explained that the combination of the pre-existing medical conditions, which are congenital stenosis, spinal arthritis with prominent bone spurs and calcified ligaments, and the injury mechanism, which was a severe car accident that required the jaws of life to take the plaintiff out of the car, caused lingering ailments related to movement and being able to walk, rather than what they allege.
Counsel. Go ahead. Didn't plaintiff's expert, though, specifically state that the delay in the surgery, which should not have occurred, specifically resulted in this plaintiff having further injury with specificity? Why the delay itself caused the injury to progress in a way that it would not have if the delay had not occurred?
Well,
If I can, Justice Kern, let's add to that. 20 pages, very detailed.
I think there's a lot there. I think it's a lot of writing. I don't think there's a lot of explanation. I think that the explanation is conclusory for several reasons. I think the crux of it comes to page 5590, where the expert says early intervention would more likely or not have improved his new baseline, increased objective functioning. He doesn't offer anything else about it. I think I have 4 reasons what he needed to do and didn't. He didn't grapple at all with the pre-existing conditions or the effects of the accident. That's not in the 22 pages. That doesn't explain, and that's also another thing we talk about with departure. He never talks about CCS, which is the specific.
Counsel, isn't that the 22, 21 pages sufficient enough to raise a tribal issue of fact, wherein you could then argue all of the things you're about to argue right now to a jury?
I don't think it's sufficient. I don't think it's sufficient. I think I think it has to be, but this court has held, other courts have held, that you need to meaningfully address and respond to the experts, the defendant's expert opinion on causation.
Why is it conclusory for the expert to have said that no matter, even if he didn't say specifically pre-existing, whatever happened before, the delay itself occasioned further injuries solely attributable to the delay? And he clearly does say that. So you're saying that it's too conclusory for us to give any weight to what he's saying?
Yes, because he doesn't make a link between what was, I understand it's about delay, he doesn't make a link between the care and then what actually happened. He just said, well, he's worse off. He didn't say how he could have improved.
Didn't he say that there continued to be tissue death during that period which would not have occurred but for the delay?
He did say about
spinal death continued during that period, which would not have occurred but for the delay, and as a result of that tissue injury and spinal death, the injuries were more severe than they otherwise would have been.
I mean, our expert had said that that's not the case because.
Right, but isn't that the traditional conflicting evidence? Your expert said it's not the case. His expert said it was the case, and it's then for a jury to determine who's right about that. Why doesn't this fit into that?
I find that I think that it's it's conjecture because he didn't offer any reason why there would have been a better baseline. And then I think that, he doesn't meaningfully address the expert's opinion on causation at all, just to say otherwise it would have been different. And then he doesn't have any supporting analysis. It's very conclusory about, well, I think it would have been different. He doesn't say why or how with medical evidence or evidence from the record about what would have been different. If Your Honors, I could also speak, we do not think that he even met the standard on departure because it's this big problem between CCS as a specific diagnosis with the specific mechanism of injury. And he just said all car accidents involving the spine are treated the same way. And that's not the case. So I think that it doesn't even raise an issue of fact as to departure. And then we also say in our brief, there are problems with the timing. It comes from a big problem with the misreading of the record about when motor skills happened, motor skills assessments were happening. And he says there weren't any for 17 hours, and it's clear that there were, and he doesn't connect any problems to anything that happened with the surgery and what happened at the surgery and the surgical plan and what departures would have happened then. And I'll come back on rebuttal.
Okay.
Good afternoon, Your Honors. Neil Bouchon from the Jacob Fuchsberg Law Firm. May it please the court. This is my first time here, and this is a stunning courtroom. So I just want to say the standard for summary judgment is creating an issue of fact. It's a drastic remedy. I want to slow down.
You have very specific case law, though, in medical malpractice actions, sort of a heightened standard that it can't be conclusive. You do have to have specific opinions. So what is your response to her argument about the approximate cause, that your doctor was too conclusory and the conclusions reached about that any delay was approximate cause of the injury?
Correct. As to proximate cause, my neurosurgeon with 30 years of experience specifically said how time was of the essence. There was a 50-hour delay when this person, my client, presented to the emergency room. The spinal cord needed emergency decompression surgery. And as a result of it, the neurological difference between when he presented on the first day of admission to the point he had the surgery, because time was being lost, was that he now developed numbness in his fingers and hands, a worsening of those neurological. So he goes on to say that it was a substantial factor in causing Messiah's physical, psychological, and exacerbation, because time is of the essence with spinal cord damage, and his residual deficits reflects the delays. Defendant is trying to argue that here's somebody with a spinal cord pre-existing condition. The reality is that the standard of care here was to have an emergency surgery within the 8 to 24-hour window, and they waited several days. There wasn't even a proper neurological and orthopedic consultation within that window of care. And the reason for is that patients who present with signs and symptoms of trauma, every hour matters. And our neurosurgeon does go into details on proximate cause. He specifically says, as a result, on paragraph 44 in his 24-page affidavit, as a result of their failures to perform a neurological assessment for 17 hours, they lost crucial time, and that led to my client having new neurological deficits, numbness in his hands, weakness in his legs, cognitive issues.
And sir, did your expert meaningfully address Mr. Massia's pre-existing condition vis-a-vis the proximate cause?
He did. And so they tried to argue that this particular pre-existing condition was not treatable and it was a risky surgery. But my expert goes on in his affidavit, as the lower court upheld, is that this is an acute spinal cord injury. And what that means is the standard of care for treating an acute spinal cord injury is to have it appropriately worked up. And you know, counsel also left out a crucial part of this case, is that their doctors misinterpreted the MRI and didn't even diagnose decompression. So not only is there an issue with delaying the surgery for an egregious amount of time, for 5 days, their defendant misinterpreted an MRI. So you have a situation where it's scientifically proven, as my expert went into, who does these and he applied it on the standard of care who does these surgeries, you have a situation where my client is losing critical time. And because of that lost time, he is neurologically getting worse and worse.
Thank you.
Thank you.
Your Honors, I think what I would say is I don't know where they ever say how he's getting worse, why he's getting worse, or what actually is worse. And to Justice Higgitt's question, I don't see any point where they say in their affidavit that what the recovery should have been, what it could have been, in taking into account the pre-existing conditions plus the mechanism of the accident. I don't think they ever say, I don't know what recovery they expected him to have. If it's zero deficit, I don't know how. They don't explain how, because this person had these pre-existing spinal conditions, which led to this specific injury that happened when he had an impact in the car accident, and it was a serious car accident. So I don't know.
Sorry, did plaintiff's expert acknowledge or recognize in the affidavit the pre-existing condition?
I don't see a play. I don't recall.
I do.
You do?
Paragraph 17, as a patient with a recent history of a motor vehicle accident and significant degenerative stenosis of the spine on CAT scan, that he was at a very high risk of neurological decompensations. And it goes on about the 17-hour delay, which was a deviation in the standard of care. So I'm not going to elaborate, but he does reference that.
But Your Honors, I will say that my last point is the same point I made. I don't see a connection between what the resulting. I feel like it's there. You know what happens where there is an injury, it wasn't perfect, you have a perfect recovery. They're analyzing backwards and says it must have been malpractice. I don't see what they say should have been better, would have been better, what he should have had as a recovery, other than the recovery that happened to him in this case. Thank you, Your Honors.
People versus Santiago.
May it please the court. Abigail Everett for Appellate, Jose Santiago. Let's start with the appeal waiver. The judge orally told the defendant, you're also waiving your right to appeal where you could argue that an error took place in this court requiring reversal of the conviction. Now, as the Court of Appeals recognized in Miracle, cited in my brief, an argument that your conviction could be reversed is very different from waiving an argument that the sentence is excessive. And if the Court of Appeals went on in Miracle to acknowledge Miracle, like this case, is a repleter case where the defendant is given a promise and told there's a requirement of treatment, and if the defendant fails, there's going to be an alternative sentence imposed. So in Miracle, the Court of Appeals criticized the waiver, saying that the court did not explain that the appeal waiver would bar defendant from not only challenging the sentence she hoped to receive, i.e. 5 years probation, but also any sentence the court would impose in the event she failed to meet the conditions.
Counsel, in this case here, correct me if I'm wrong, there was an alternative to incarceration, right? He had to go to a program, but if he had failed, my understanding is, my reading of the record here, the sentence would have been 4 years and 2 years PRS.
Correct, Your Honor.
And the people did not, I guess, oppose to the court when the court imposed lesser than the 4 years, went to 2.5.
True.
To 2 years PRS, right? So how does this work in terms of whether or not the sentence is excessive? I mean, the court didn't,
Well, first of all,
took a
this
lot
is
into
person,
consideration.
We're talking about a drug addict who, it's a $40 buy bus sale. He was originally going to get a conditional discharge at a misdemeanor. He ended up with a D felony, 2.5 years in prison, which he's still in prison. He did not get the minimum post-release supervision.
Well, counsel, that was because the plan was for him to get treatment for his drug addiction.
Right, and we're not raising the outly issue, but I'm sure you've looked through the hearing. This is 4.5 years through some really tough times. We've got COVID, we've got the DA acknowledging his wife was sick. He was arrested for a couple of drug cases, so he's struggling still with his drug addiction. Judge Ong raised in an earlier case today about the reasons for reducing a post-release supervision, I believe. But this court, and I've cited in my brief, has repeatedly found in certain cases that it's appropriate to reduce the term of post-release supervision, particularly a case cited in my brief, a
He is on PRS right now?
No, he's still in.
He's still in, okay.
And there are cases where this course was reduced even after less is more went into effect. So I'm really asking the court, under the circumstances of his struggles, to reduce the post-release supervision to 1 year, the minimum, so he could have the minimum on the post-release supervision in addition to the minimum on the sentencing. He tried, he was on the methadone, the DA acknowledged he did that, but he struggled with doing the programming that the programs required. That's true. Now he's been in prison. He's going to be in prison for 2.5 years. He will have drug treatment in docs. This is not a case with a $40 buy and bus that it's appropriate or necessary for him to be on post-release supervision longer than the minimum term that's required by law. If the court has any other questions, I'll wait for rebuttal.
Thank you very much.
Good afternoon, Your Honors. Andrew Lozides for the respondent, Officer Darcel D. Clark. May it please the court. Your Honors, considering what happened here, the defendant's sentence is far from excessive. The defendant was indeed caught with a felony drug bust situation. The court gave him an offer. It said that if you complete a drug rehabilitation program, you will successfully complete it. Instead of having a felony on your record, you would have the misdemeanor 220-30 on your record instead. But he failed to complete the drug rehabilitation program, and over the period of 4 years, he was removed from the program. He actually at one point was removed because he got into a physical altercation with someone else at the program. He was caught with several other drug bust situations, and then so finally, instead of getting the initial promised court sentence of 4 years incarceration followed by the post-release supervision, the court, with our office's consent, considering this defendant's history of drug abuse, said, we're going to give you 2.5 years instead and 2 years post-release supervision. And furthermore, there was a valid waiver of the right to appeal here. The court distinguished the trial rights from the appeals rights. Defendant signed the written waiver of the right to appeal. The court made sure that he was represented by adequate counsel, that he understood everything he was giving up. Therefore, everything should hold water here. And unless if Your Honors have any questions, then we will submit on the brief and ask that this court affirm.
Thank you.
With regard to whether he was in a physical altercation, as I noted on my brief at page 8, originally there was a suggestion it turned physical, but then it was clarified at the Appellate hearing, and the prosecutor below accepted that it was not a physical altercation. He was removed from the program, but it was not a physical altercation. And I would submit that this is not a situation where the judge made it clear that he normally would have the right to appeal after a guilty plea. When the judge talked to the defendant in the court, this was classic conflation. He did the Boykin rights about the trial rights, and then he said, and you are also waiving your right to appeal. That's classic conflating between the waiving your right to trial rights that you always give up in a plea. The judge did not specify, and probably because this is a 2018 plea, this is before a lot of the litigation happened in the appeal waivers, but this is a bare bones appeal waiver. It's misleading to the effect that it talks about reversal, and I would say that the written waiver did not cure these problems. Thank you, and we ask for reduction.
Thank you very much. Joseph versus Morsali.
Good afternoon, Your Honors. Meryl Haft of First LLC for Respondent. Since 2020, Appellant has engaged in a pattern of litigation abuse against Respondent. The parties divorced in 2019 in Texas. Pursuant to that divorce decree, they had agreed that the mother could relocate to New York with the parties' 2 daughters. The Respondent did that in September of 2019. In 2020, the mother filed a petition in family court seeking an order of protection against the father. Referee Adams of the family court conducted a trial that lasted over 2 years, and she made a finding that the father had committed a family offense against the mother. During that trial, in retaliation, the father started filing multiple petitions in multiple courts. He filed at least 4 applications in Texas. He filed a motion to the family court seeking to modify custody, which he then withdrew. He then filed in Supreme Court, which is the motion underlying this appeal here. Referee Adams then issued her decision in April of 2023. Rather than withdraw his motion, he doubled down, he filed another motion. He appealed the family court decision to this court. A panel of this court affirmed family court. He has now filed 2 motions to the Court of Appeals seeking leave to appeal that decision of this court, and he has perfected this appeal, which brings us before you today. So I ask that Supreme Court's decision be affirmed. Justice Chesler of the Supreme Court did sufficient inquiry into the allegations of the father. He reappointed an AFC for the child, the same one who represented the child in the family court matter, and that AFC said that she did not support a change in custody. And I ask that this court affirm the Supreme Court's decision. Thank you.
Thank you so much. People versus Thomas.
Good afternoon, Isabel Patkovsky on behalf of the Legal Aid Society representing Norwood Thomas. Your Honors, Mr. Thomas pled guilty to a felony in a virtual meeting room without ever being asked by the court if he consented to so doing, because that was a violation of both New York state law and the state and federal.
I think your argument is that, from what I gather, defense counsel consented, and you're now arguing that the court needed to confirm defendant's counsel's representation that defendant consented.
Our argument is that under CPL 182.30, it's clear that the consent must come from the defendant himself, not from counsel.
So counsel can't consent on behalf of their client?
Exactly, just the way that my attorney couldn't waive my right to appeal, just the way my attorney.
Well, if we were to agree with that, that's revolutionary, because we got a lot of situations where the defendant's counsel do represent to the court. And now, if I were to agree with you, is that going to cause a little bit of a stir, don't you think?
Respectfully, Your Honor, having looked at many of these cases that were during a relatively brief period of time, right? So taking a step back, going back to 182.20, in normal times, felony pleas cannot be virtual. It doesn't matter if everyone consents. They have to be in person. That's what the legislature has decided.
But we were not in normal times.
Exactly. And so briefly, felony pleas were permitted. And having looked at many of those pleas.
But let's talk about why they were permitted. Right? They were permitted because many defendants didn't want to come into a courtroom. And it seems from the record that your client was somewhere else and also didn't want to come into a courtroom to expose himself to potential COVID risks because he was with his family.
Yes, Your Honor. I think the executive order was passed because of the realities that everyone was facing, defendants as well as attorneys and judges and court staff. But when you look at what courts did during COVID with felony pleas, the fact of the matter is that they engaged in colloquies, in Bonilla, in Lawhorn, in LaValle, in every case that I could find.
Let's just stay looking at this case, your client's case, right? And when we do that, what happened here that was not proper or legal?
What happened here was that the court didn't do something very simple, which was say, Mr. Thomas, do you consent to appearing virtually?
He was on video, though. This is a situation where he was remote, he's on video, right? And the counsel represented the court that he's consent. But I'm not seeing in the record, and I missed it, that he objected to that counsel's representation, right? Like, I never consented.
No, but it wasn't his responsibility to object to that because no one informed him of his right to be.
He also asked for other adjournments to be virtual because of the fact that he didn't want to come into court to risk exposure to COVID.
His attorney made a representation to the court. That's correct, Your Honor.
On his behalf.
But our position is that under the law, this is a personal right that belonged to Mr. Thomas, not to his attorney. And that's completely...
But his attorney wasn't requesting these accommodations because of his attorney's desires. The representation was made on behalf of your client.
Yes, we're not suggesting that his counsel was ineffective. We're simply saying that this was a right that the courts regularly recognized during the pandemic while these orders were in effect, belonged to the defendant.
Going back to what my colleague, Justice Owen, said, you know, when defense counsel said, yes, you know, my client wishes to proceed virtually, defendant didn't interrupt and said, no, that's not correct, I object, right?
Respectfully,
That's usually a yes or no.
Client did not say that, no.
Let me ask you another question. So now there was a back and forth colloquy between the defendant and the court, asking for a lot of things. Did he ever say, you know, Judge, I object to the way this is proceeding? Did he ever register any type of objection? Because they were, you know, he was kind of vocal during the, you know,
He asked
proceeding.
questions. He never made any objections.
Well, he didn't just ask questions. He asked for other relief as well. He tried to advocate on his own behalf.
He asked if it would be possible to have other relief. That's correct.
Okay.
But I don't think that this court has ever said that a defendant has to personally object.
I'm concerned about how your argument is phrased, that these are unique, those are extraordinary times that we lived in, right? In terms of no one want to be anywhere because of COVID, right? That if I were to agree with you now that, you know, that in that situation where counsel was there saying, my client's consenting to be virtual and remote, that the court is required now to double check and ask on behalf, the court has to ask the defendant, do you consent, right, coming forward? I'm concerned that if I would agree with you and say something like that, that going forward, someone's going to pick up on that and say, you know what, every time now that counsel consents, that's not good enough. You're going to have to also have defendant, you're going to have to ask the defendant, do you consent also? That's kind of, how does that work?
May I reply?
Of course. No, you can't answer it. No, I'm kidding. Yes, go ahead and respond.
Two things. First, I think this would not really affect very many cases.
Oh,
because as
there's
far as I can
creative
tell-
lawyers out there, I'll tell you that.
And as far as I can tell, every court except this one was actually asking the defendant directly. Second, what we're asking for is, it's not anything elaborate. It's simply asking the defendant, just like with every other right in the plea process, the boycott, the appeal waiver, every other step, this is part of the plea, and you just have to ask, do you consent? That's really all it is.
Thank you.
Good afternoon, Your Honors, and may it please the Court, Caroline Williamson for the people. As a threshold issue, defendant's claim is unpreserved, and there's no reason to reach it in the interest of justice. This court has already declined to address the defendant's argument that he didn't consent to a virtual resentencing proceeding because he failed to preserve the claim, and it should do the same here because the record makes it incredibly clear that the reason defendant didn't object at the time is because he wanted a virtual proceeding. The court's language at the very outset of the proceeding was, as I understand it now, first of all, the defendant is requesting that we proceed with the plea virtually. Is that correct? And so it's very clear from the record and from the context of these proceedings that defendant had before this personally requested, not
Doesn't
just—
that sort of beg the question, though, because your friend's point is it didn't come from the defendant's mouth, right? It came from counsel's mouth. And so was this one of those cherished rights that could only be waived by the defendant, him or herself?
Well, we do believe that this right was a personal right and was waived personally by the defendant.
Well, the question was posed, the court posed that question with both the defendant and counsel present, right? So that if the counsel said yes, then defendant could say no.
Correct. And defendant was present, and we believe that defendant, it's very clear, personally did waive that right. Just because defendant didn't personally verbalize that waiver doesn't mean that the right wasn't the defendant's to waive.
Well,
And that
the other way to look at it, he didn't contradict his attorney.
He did not. And he spoke, as you said, repeatedly throughout the proceeding. He never contradicted his attorney. And we believe
Actually,
that—
he was advocating for himself, so he was co-counsel.
Exactly. And we believe that the New York Court of Appeals has, in fact, already rejected a blanket rule requiring a defendant to make personal representations in order to effect a voluntary and knowing waiver of the right to be present. That's People v. Epps. Voluntariness needs to be assessed in the context of the case, and here it just could not be more clear that defendant did not want to be there because of COVID. He, as you said previously, or throughout the proceeding, requested other adjournments because he did not want to be there. And he, before this proceeding, spoke with his attorney. That representation was made multiple times, and he had told his attorney to make representations on his behalf to the court. And for that reason, we believe that the judgment below should be affirmed.
Thank you very much.
Very briefly, I think the question of preservation is in a sense one and the same with the question of whether the attorney could waive this on behalf of Mr. Thomas or whether Mr. Thomas had to be asked specifically. So I won't address that more except to say that unless I'm mistaken, this court has not actually addressed this question. The third department has. I believe that my adversary was referring to Witherspoon. But I want to take a step back and talk a little bit in the time I have left about why this matters. The fact is that, as I said at the beginning, felony pleas are normally not allowed virtually. We're not contesting that they were allowed at the time that Mr. Thomas pled, but there's a reason that they're typically not allowed virtually, and that's because we think it's an inappropriate forum for such a life-changing moment in someone's life. In Mr. Thomas's case, this was his only ever felony, and it sent him to Rikers Island for 6 months. Courts, not just in New York State, but across the country, have acknowledged that virtual hearings do not sufficiently acknowledge defendants' humanity, that they disadvantage criminal defendants because it makes it less easy for them to talk to counsel, their attorneys not standing next to them, and much easier for even a well-intentioned judge to not acknowledge them. And so for those reasons, we urge you to take this into account and to vacate Mr. Thomas's plea. Thank you.